So we are on Section 11, and this is the first half of Section 11 we're on. And discussion is about the valuation of damages. And, you know, in the real world, obviously, damages become important because you've got to, that's how we ultimately make our money, or how we make our money on hourlies, by defeating the other person's claim to damages. So when you're talking about remedies, very common in civil cases that it's not an injunction, but someone's looking for money. And I think it's sometimes a more difficult transition for you guys to start to think more practically, what is that proof look like with respect to the valuation of damages. I think you get the basic concept, and you hopefully could repeat it to me, that the plaintiff is entitled to be made whole, to be put back in the position they would have been but for the wrong done to the plaintiff. And we've already looked at contract damages, where we looked at expectancy damages, what the profits that the plaintiff expected to reveal had there been no breach of contract, or reliance damages, there having been a breach, what the plaintiff now has expended and wants to be put back in the position that would have been had there never been a contract. But here we've got some other valuation of damages issues, and this is really where, at least in part, you start to think about, okay, how do I tie evidence to pleading my claims, to providing the proof of that loss by way of admissible evidence at trial. And so we've got to think a little more about the practical aspects of proving damages, not just the abstract notion that the plaintiff is entitled to be made whole. What does that mean when we start to think about what evidence are we going to use to try and show those losses that would make us whole? I want to make a mention of a case that Solange gave me earlier this week, and it says insurer must pay $8.5 million to exotic dancer injured in car crash. And it's an interesting case from out in Worcester, and she was a dancer at a Worcester strip club, and as part of her job, she drank a number of tequila shots throughout the night, a dozen all told. Having consumed a dozen tequila shots, one of the bouncers walked, half carried her to the car, her car, opened the car door for her, gave her her keys, and let her drive away. And then she was in a serious car accident. And then over the period of a number of years, they've been litigating this suit. And so ultimately, the company is liable for the damages. She was a 20-year-old as well, so she was underage. And this also, then the insurance company wanted to disclaim any liability, and there was a significant insurance policy on the strip club. And ultimately, the court found, and this is similar to the cases we did on our insurance problems, where we looked at 93A and 176D, the court ultimately found, the federal court found, that the insurance company did in fact violate both 176D and 93A, and issued its judgment. And that judgment is for $8.5 million as a result of her damage and the damage that the insurance company did by not engaging in good faith settlement negotiations, not having reasonable standards to investigate the claim. It's the stuff we looked at when we did those insurance practices, that segment of it. So it's a very interesting case, very large judgment. Now she did, just so you know, I mean, it's not like they're giving away money. She's had, is it a dozen reconstructive surgeries on her face? She also, when she was initially injured, I assume it continues, she had a brain injury as well. So it's not just giving away the money, but it's an interesting case, and it's an interesting application of those principles we talked about with respect to 93A and 176D, and the obligation the insurance company has to deal with their insured fairly. It's an interesting way they went about doing it as well, is that the strip club, Centerfolds, agreed to an agreement for judgment with the plaintiff, the injured person, and then assigned their rights to go after the insurance company for bad faith actions vis-a-vis their insured, and then that was the claim they actually pursued and were able to successfully get the court to agree that the insurance company violated a number of different principles under 176D and 93A. So it's a huge judgment, but it seems that it's well-founded on the principles that we looked at. So it sounds like a lot of money, but she's got serious brain trauma, and her facial injuries required more than a dozen reconstructive surgeries, which wouldn't sound like she's done either at this point. So it's a lot of money, but it's not a lot of money if you're 20 years old and your life has been permanently altered as a result of it. But it's an interesting case. Name of it is Capital Specialty Insurance Corp versus Higgins. And part of it is, and part of what I want you to start to think about, well, so what would we offer for damages with respect to evidence? So she's a 20-year-old stripper. We've got obviously the meds and the things like that. But what type of evidence do you offer about lost wages? What type of evidence do you offer about pain and suffering? How do we get the jury to start to understand the full extent of the value of these injuries and claims? And you've got to try to understand it. Well, what's the testimony we would offer? Are there any documents? What is the evidence? You know, when you think about it, taking the abstract notion of proving her damages and thinking, well, so what does that mean by way, if I'm trying the case, what documents would be admissible? What documents are relevant to the claims and the like?
Probably her medical history, and what you're trying to do is paint the client as a victim, that she's somebody that is just like you and me, as just a regular person that just...
Don't you think that's a harder sell in a case like this, though? I mean, we could say she's a regular person, but she's not, right? She has a different lifestyle and activity that some jurors will have trouble getting past. What is your damage claim beyond? I mean, I assume it's going to be, you're going to try and create, she's not going to do this forever. Doesn't seem like a occupation that has a long career. So
Switch to the day shift.
So, yeah, well, the day shift is not. Go ahead.
I would say probably subpoena the club owner to have an idea of what the average income is coming in for each girl.
But how long do you think that is, right?
I would say in that world, it's really based on looks and how you age, right? So I would say she's 20, 10 more years. I would give it up to 30.
That's not going to get us into the $10 million range, right? Because her damages go on forever.
And I think another important piece too is where the club is located.
Yep.
That dictates how much money the girls are making. So if it's in Miami, then it's a lot of money to be made in Miami as opposed to Springfield, Massachusetts.
Yeah, I would think Springfield and Worcester, we are looking at less, right? I mean, but that's those, you know, that is where it took place. That was what she was doing. The liability is a pretty straightforward part of that case, and sometimes it's more challenging. But liability, I think we have a better handle on how to put that proof into motion. I think it's the damages part we think about, okay, I get it, I get what I'm looking for, what is the evidence that allows me to get there? We're going to look at some of these.
So, where the club is located,
Yeah.
like you just said, it should be a factor.
Well,
It
well, because of
depends
what
on
the average, what they would make, what the average dancer would make in that location.
Okay, the average dancer will make an allocation. But I am more into how much of an insurance policy is slapped on this particular.
Okay, but here's the thing about this, okay? The evidence of insurance is generally inadmissible evidence,
Oh.
okay? But, so the fact is, whether you have a $10 million policy or zero is inadmissible with respect to what my damages are. It is relevant when we start to think about what's the value of my case as to whether it makes sense to settle or not. If there's not a lot of money there, and there's not going to be a lot, and there aren't a lot of hard assets and the like that I could grab potentially or seize, then I've got to be realistic about what the value of the case is. If on the other hand, well, I'm always going to be realistic, but if on the other hand there is a huge insurance policy, or there are tons of assets available, then realistically I know there are ways to protect myself if I have to litigate this to judgment, that I can likely collect on it so that I will still be reasonable, but I don't have to discount it because of the worries about collectability or no insurance and things like that. It appears, and that's what happened here, it appears that Centerfolds had a huge policy, but the insurance company doesn't want to engage in a reasonable discussion at all, because that's the other thing. I would imagine with the problems that I could foresee on damages on this, that they could have settled for a lot less than $8.5 million. Instead, they litigated for I think it's nearly 10 years. I think the first suit that I saw when I started to backtrack on this was 2011. So the insurance company has fought it tooth and nail all the way along. And I would imagine that the plaintiff would likely have, if there had been a reasonable offer earlier, and by reasonable, could be 10 cents on the dollar compared to this judgment. Got to have money at some point. That, yeah, it says by early 2001. Yeah, their liability was reasonably clear by early 2011. So the thing has gone on for 8 years. So they chose to use a scorched earth defense, and now it's costing them. But you need to think about what we're going to offer for proof in these cases. Let's talk about Strzelecki versus Blazer versus Lakeside Industries. But this is one worth looking at, especially when it has those insurance issues, and that's probably what I will definitely do. This is add this to next year's cases, because it hits both issues, and it's the way in which normally, if you're not the insured, you don't get to raise those 176D arguments. That's, in essence, a contract claim between the insured and the people that wrote their policy, because I wrote the checks, that was our agreement. The case I gave you here was it was an odd one where the court said, no, under those circumstances, the injured party can still go after the tortfeasor's insurance company. There aren't many cases on that. What this one is, and this is the more commonly way it's done, is, okay, I know you don't have a lot of money or a lot of assets, but I know you got a big insurance policy and they won't even deal with me. And so what they did here is they, in essence, agreed to a judgment of about $7.5 million that would enter against Centerfolds. Centerfolds then agreed to assign whatever rights it has against its insurance company to the strippers, attorneys, and her to be able to pursue that 176D and 93A claim, the bad faith practices with their insured. And that's what the court ultimately found, is that the insurance company wasn't reasonable here at all. And judging by how long this went on and the problems that the case had, it looks like they pulled out the old scorched earth defense and must have spent a fortune fighting this, where, it's a big claim, but at the same point, my guess is this could have been settled for low seven figures at most, had they come to that realization a lot earlier. The accident initially happened on November 27, 2010. So it's 9 years. It's been percolating through the court system up and down. It's a long, long time. A lot of plaintiffs would have walked away before then, and a lot of plaintiffs would have taken a lot less before then simply because they run out of money. This poor girl, not likely working during that time period, and not working, making much money because of her physical limitations to begin with and her need for additional surgeries over time. Not sure how much she could have been working at all. Probably a lot of public assistance simply because of her. She got serious brain trauma and needed a dozen surgeries. Doesn't leave a lot of time. So she would have taken, and most plaintiffs would, because they run out of time, they run out of money. They've got to try and take care of themselves.
Yeah, can't you make an argument saying that the plaintiff has an insurable interest by pretty much the premise saying that the owner of the club actually got this insurance to protect against the liability?
You can, but there are, yes, in essence, a third-party beneficiary argument. The problem is, and I think that, I agree with that, but there's not as many cases as you would think that support it. Again, so it goes back to that argument about privity of contract. If you didn't contract with them, you don't have the right to try and enforce those rights. And so there are ways to work it, and that's what this one did. It's just the status of the law that only the contracted individual generally can. But there are cases like this one, but this one is the way in which it's typically done. The other case was in the book where that decision was issued and then withdrawn. So let's talk about personal property, because the first case we have deals with, I think it's real property, Strzelecki versus Blazer versus Lakeside Industries. So we're trying to value, and by valuing, trying to put numbers in the real world so that the jury has the ability to find for us and come back with a number and an amount that makes sense to put the plaintiff back in the position they would have been but for the wrong done to them. So this was a wood stove, and as a result of installing the wood stove in the premises, it destroyed the plaintiff's home and contents. So we've lost both real and personal property here. And so the question, in part, becomes how do we offer that proof? When we take it away from the abstract about the plaintiff's entitled to be made whole, what that means is what does making it whole, make them whole mean? So let's talk first about the real property. What proof, what evidence would you offer? Well, first of all, what's the measure for the damage to real property? What is my measure of damages?
Market value before and after.
Okay, so market value before and market value after is one means of measuring that. How do we establish market value?
Tax assessor's office?
Well, is that fair market value?
Not necessarily.
Is that hearsay, by the way, too?
Yeah.
Okay, so how are we going to do this as a practical matter? One approach to what I lost as a result of the damage by the fire is market value before and market value after, right? The market value before, reduce the market value after, the difference is what I lost. Market value is one approach. So how do I establish market value then? Okay, I get it, market value. How do I establish it? Ray says one thing we can look at is the assessor's information, right? Tax assessment, it's supposed to be 100% assessment, but that document itself is hearsay. So do I call the assessor in or whoever's the keeper of the records? Is that somehow, I don't know, an official record or report or a business record of the assessor's office? Is that an exception to hearsay?
It's an official record.
Think it's an official. So we think we have a couple of exceptions. So we're going to need someone from the assessor's office to come in and offer the assessment value. Is that a fair market value, though? Are you comfortable that that's what it is?
I would say no, because sometimes the assessors don't reassess the houses until they're actually.
Well, you're right. I think in Mass, I think it's supposed to be every 3 years, but I don't think most people would sell their home for what it's assessed at,
Right.
right? I mean, they hope that they're getting a good deal on the assessment. And so by the way, then that's the other side of this. So if the assessment isn't the fair market value, it's a low ball. Well, the insurance company has lawyers that are going to represent them and are going to say, well, it's all it's assessed at is X, right? They try their cases too. So you've got to figure out what we're going to do with that. Okay, how else would you establish market value?
Maybe get.
By proof.
Maybe, I forget what you call it, the MLS listing or something of the nature, and get a broker to testify as, a broker within that area to testify as to the value based on the square footage of that home. Based on
Did they actually go and do an appraisal of your home, of this home that's now burned?
Yeah, I would say yeah, for the purposes.
Okay, so you're gonna have an expert then,
Right.
someone who's qualified by beat, right? Background, education, experience, and training, do an appraisal of that home, provide that appraisal. Again, the appraisal's hearsay, so they're gonna have to testify at trial. Assume we go to trial, right? Okay, so one way is an appraisal before the damage, likely, I mean, it's an opinion, but it's an estimate, probably, and they can get a pretty, and I'll explain that process in a minute, but they can get a pretty good value with respect to the appraisal, because if it's done correctly, they take into account everything with respect to the house, and then they take into account the community. They look at what we call comparable sales, other two-bedroom homes with one bathroom on this square foot a lot. They'll make an adjustment depending on location or windows or other amenities it might have, and then they'll give you what they believe is the fair market value of that property. So, but it's their opinion because it hasn't been sold, so all we know is this is what I say it is, but because of their qualifications, they get to offer their opinion at trial, but you got to pay for that. So a real estate appraiser, between doing the appraisal and then testifying, it could be $2,000 to $5,000. And that's the other thing here. It's a little more of a complicated appraisal because I've got to give you both before and after, right? Because maybe now, if it's totally destroyed, we're talking about the value of a lot. That's probably easier for the appraiser than to say, well, we got reconstruction here, we're going to need X, Y, or Z. But market value before and after, and the difference is your loss, right? Now, even on market value, within it, as you start to think, there are different methods of establishing market value. One of which is what we just did, sort of a straight market value. A willing seller and a willing buyer, this is what the number would look like. Another way to evaluate the value of that property is on an income approach. What the property, if rented out, would generate as income. Based on that income, this is what an investor would pay for it. So even when we talk about market value, there are different means within that of establishing the market approach as to how you would value it. Should it make a difference if it's my home versus a rental property? Suppose this is the home that I want to live in. Because one thing we haven't talked about yet is, why shouldn't I get the cost to fix it? Why shouldn't I get the cost to put it back in the position it was prior to the fire, as it was in this case, right? Replacement cost, in essence. Put it back in the position it was prior to the fire. We're assuming here that the damage was done as a result of the negligence of the manufacturer of the wood stove. So why shouldn't they then have an obligation to put it back in the position monetarily to what it would have been prior to that? What if that's what I want? How would we offer proof on the cost to put it back in the position it was prior to the fire?
You'd deduct deductions for depreciation. Because if you were to put
So it's replacement cost
Right.
less depreciation.
Right.
Because you don't get a new roof, you get a 10-year-old roof.
Well, if you were to put it as brand new,
Yeah.
the case says that it would be as if they were going into a new house, not something that is a
Okay,
fair
okay, so
market.
slow it down though. So then you're entitled to replacement cost first of all. How do we establish that?
Fair market value.
No, but fair market value is what the house is worth, not the cost to replace it, not the cost to restore it to the condition.
So I would assume we would need another expert.
Yeah.
Oh, we need
Who's this expert now? Who would qualify by
a
B?
construction foreman.
Sure, some contractor, someone who's in that business who could tell us what the damage was and what the cost to replace that damage is, right?
Right, because we would need to look at how much the lumber costs, how
Right.
much the tiles and et cetera.
So again, but this is again, because it's opinion, it's not fact necessarily, so they're gonna have to be qualified by background, education, experience, and training, right? And then, okay, so that's the replacement cost, less depreciation, you're saying. So how do we, because they don't get the new roof and the new boiler, they get a 10-year-old roof and a 10-year-old boiler, so somehow that cost to replace has to be discounted by some percentage, right? And so we're gonna need to offer some proof on that. Because that's another way to value the damage, is replacement cost, as it says here, less depreciation. And so, look at in numbers 1 and 2, the rule of damages for property loss is as follows. It is the settled law of this state that the measure of damages to real property, if permanently irreparable, but permanently irreparable means it can't be fixed. Where a lot of times it can, but it's going to be by an expenditure of a lot of money, is the difference between the market value before and after the damage. That was the first thing we did, right? Okay, if it cannot be fixed, market value before, market value after, the difference is the loss, boom, we're done. But as we've already said, that, as you start to think about it, okay, proving market value is not so as easy as simply saying, well, the market value is X, or here's the assessors. We might well need an expert. I also think there are jurisdictions where you can argue the homeowner, the person who lives there, that is one of the things they can opine about, because people are generally familiar with their own things, and they know the value, or we know that whatever they tell us is somewhat suspect. But when you're talking about people's homes and cars, they have some understanding of what they think it's worth, and oftentimes the court will allow that evidence, even though it's still opinion. Then it goes, this little language here goes on to say, however, if the injury is repairable and the expense of repairs is less than the market value, then the measure of damages is the cost of repairs, right? You don't get a windfall on market value. If we can fix it, you're going to get the property fixed as to what was required to put it back in the position it would have been but for that wrong. But then the court goes on to talk about, but unless we provide something for depreciation, then the plaintiff is getting a windfall, and that's not right either. So we've got to figure out how that depreciation would factor into this, but the defendant is entitled to a credit for the depreciation. And what that means, if you think about it, is so the plaintiff really isn't likely, we can talk about being made whole, but they're going to be out of pocket here before we're done. And the better example of that is what we've talked about before, is with respect to personal property, right? Is, okay, you've got a couch or a big chair you love right now, but if that's destroyed in this fire as well, you don't get a new chair and you don't get a new couch. What you get is the new chair, new couch, less all of the depreciation. And if it's a matter like a couch or a chair and it was 10 years old, yeah, you're not getting much at all. And you need to go buy a new couch and chair if you want to sit in your living room and watch the ball game. So as you start to think about it, it becomes a little bit problematic. But this is the part. This is what we have to do though now, is take sort of that abstract idea about it and say, well, how do we make this concrete when we start to think about proof? So you can tell me your couch cost you $1,500. That's not what your loss is, and that's not what I'm obligated to pay you. The house we're gonna get to, the house we're gonna try and help you out here and get this repaired, but even that is not necessarily going to make you whole. And again, if your personal property is market value, well, go on Craigslist and see what the market value is of a 10-year-old couch or a 10-year-old chair. It's not going to be a hell of a lot, but that's what we're talking about. And so we don't have to be relegated to simply taking what the insurance company says, but you need to prove market value. Sometimes if you guys have ever had a car accident, and they say, well, your car's totaled, I'm sorry, we're going to give you X. Well, if X doesn't replace the car I lost, then you're not giving me X. But then that means it's on us to give them proof as to what the market value truly is. The fact is that they have a book, but that book doesn't necessarily mean I can buy the car for that. So if you find a car, the same car at another dealer that's $2,000 more, that the value is, say, it's 17, because that's what it costs, then you have an argument by proof as to what you actually lost. And so you need to be able to think about, okay, so what proof is it that to show actual value or the replacement cost and the like?
What if you produce a receipt that you paid originally, that cost? Couldn't they calculate the depreciation from that receipt?
Oh, sure, they could. Yeah, they could. Well, that establishes a market value sometime in the past, but I'm not so sure that is the route you want to go, simply because as a general matter, personal property depreciates, I think it might be 7 years. I mean, I think for tax purposes and the like, it's an incredibly short period of time, where the useful life, the value, is significantly longer. So you might be much better off going online or going out and really trying to figure out what that certainly a used vehicle, we have relatively easy time establishing what the market value is. Used personal property is difficult simply because there isn't the same market for it generally. But it's a good way to start as to, well, what would the market be? What would a willing seller sell a piece of property, sell whatever it is, and a willing buyer pay for that good? But then that means you've got to think, okay, so that's what it is. Now how do I make that proof admissible? How do I take it's a document, or how do I take someone's opinion and make it admissible at trial? Because at the end of the day, when we talk about taking these cases to trial, that's what it really means is, okay, so forget the abstract, who do I call, and what is it that they're going to say, and is that information admissible under the rules of evidence? Because if you can't do that, then I don't have to worry about really negotiating with you in good faith, because I don't think you're going to be able to execute the finish on this anyway. So it's important to start to think about, okay, so what should I be getting? And that's the other thing. What should I be getting in discovery that will be admissible to help prove these values and the like? First starts obviously with knowing the law as to what the measure is. And here you've got a pretty good example of what they are looking at. Look at the language at the top of 314. The general principle is that the proof of the amount of damages may not be founded on mere conjecture or speculation, right? I mean, it's not guesswork, and it's not, well, I think it's worth this. It can't be guesswork or speculation. But it also isn't, mathematical certainty isn't required either. We're never going to get to that point, right? We create a world that didn't exist and now ask you to buy into it. You're not going to get mathematical certainty, and I'm not required to. But it can't be just what you're speculating was the value, or what you guess is the value. That's not going to do it at all. Now it says in this case, the property destroyed was a home which is a unique real property in its contents, and only a secondhand market exists for it. There is a difference as we start to think about it when you value someone's home as opposed to a rental piece of property that a landlord may rent out. Right? There's a principle, we're going to see it in a few cases as we move to the conclusion of the semester, where a person's home is their castle. We protect it to a much greater extent than we protect a lot of things. And so we favor the ability of the plaintiff in these situations to be able to rebuild their property, even if the cost to rebuild is high. You know, sometimes we worry about economic waste. Listen, if, you know, we'll give you market value because the cost to replace it is just too high. Well, if it's my home and you're responsible, you're liable, you violated the law for the destruction, then why isn't it the cost to replace that property as opposed to straight market value? Right? There are cities and towns like Lawrence where the market value of that home may be a lot less than what the cost to replace that property is by reconstructing it. You know, with the beautiful, Jesus, wood is ridiculous. If you've done any work lately, wood is ridiculously expensive, right? And if imagine on some of these big homes, where I grew up in Dorchester, we used to have these huge houses on Melville Ave, probably about 6,000 square feet homes. And Lawrence has many like that, sort of that Victorian era homes where the woodwork is incredible. And if you just think about the raw wood in some of these places today. If you had a serious fire, there's no doubt in my mind the cost to replace that home is likely going to exceed what the market value is. But if you're the homeowner, this was your house, this is where you want to go back, I can pull the heartstrings more. This is your parents' home, this is the house you grew up in, and you want to die in this house. A lot of people, that's the way they are. Well, why shouldn't I have the ability to say, I don't want market value, I want the cost to replace it, even where it exceeds market value, because that's my measure of damages. I'll bring a contractor in, he'll explain what the damage is, he'll explain what the cost to replace it, to put it back in the position it was prior to the fire or whatever the loss occasioned the loss. That's my measure of damages. And frankly, I would argue and stick with that even where the market value is less than that, because it's your home, and we do protect the home to a greater extent. Now, is the defendant entitled to some deduction for depreciation? Sure. But, if the house was in good shape, the fact is that when we talk about deduction for depreciation for real property, a lot of times these older homes, if well maintained, that oak and that maple and all that nice wood would have lasted another 100 years. So the fact is you don't get the same deduction for depreciation as you do when we're talking about personal property, because they expire that much faster. But so now we've got a different rule potentially. It's not just market value or replacement cost if it's less. It could be replacement cost period because it's my home. Go ahead.
So if the value appreciates, you're trying to say that they would have to pay the difference of the appreciation? Like, how you have a 17th century Victorian home, right? That value
well,
of
don't
that
say
house,
17. Let's just say, okay, let's say it's a 5,000 square foot home in Lawrence that is worth, that if to sell it, if you had a market value, if an appraiser came in, market value will say, the appraiser is going to come in and say market value is 400. But if there's a total loss other than the foundation, then the builder says the cost to replace that home is 500. Now, one argument is, well, if the market value is 400, that's all you've lost. Here's your 400, goodbye. On the other hand, if I'm the homeowner, I'm saying, no, you keep your 4, I want 5. I want to stay in this home, I want the cost to replace it. That's what I'm entitled to, that's what I lost. Now, there's still more moving pieces to this, just so we understand, right? Because even market value in that situation, the market value of the home prior to the fire was $400. Well, you got to sort of take out the value of the lot, right? So you're still not even necessarily getting a check for 4. You get a check for 3, and you sell your lot for 100. So then arguably you're still made whole. But I'm saying no. In this situation, I want replacement. I want the replacement cost for the damage. And he said, and my guy says that's $500. You want to take a 10? Just leave the depreciation off the table. $500. Now, if I get that check for $500, am I going to rebuild it? Because I can get my $500. I still have a lot worth $100. So now I'm up to 6, and I can go buy this same house in this same neighborhood for $400. How many of us are going to pocket the $200 and go buy the same house for $4? Right. Well, but some might not if it's their ancestral home and that's what they want. And the point I want to say to you is, well, we argue about it. We use the law to say, well, if it's the home, you're entitled to replacement cost less depreciation, even when it exceeds market. The problem is anytime you're arguing it exceeds market, you're going to have a tough sell. Because we know one measure of damages, as we started out, was the market value for the home. But when it's the home, your home, market value may not be enough. Because while we don't award damages for market sentimental value, we do protect people's homes. And we protect them in many, many different ways, as we're going to see. And that's because it talks about this language in 4 here. A home being unique real property. And we're going to protect that unique real property in a much greater way. Now, they also get into, in this case, well, who can tell us what the value is? And you've already decided one person that can tell us what the value is the expert. The expert who's qualified through background, education, experience, and training certainly can tell us, in their expert opinion, what they believe the value is. And a good real estate appraisal, and not just, sort of a market value analysis, a real appraisal done by a qualified appraiser is going to show you in pretty good detail how that is arrived at. It's going to look at comparable sales in relatively recent time. And when you look at it, you feel relatively confident that, give or take some, 10 or 20 grand or whatever number you want to say, that's probably a pretty close estimate to what the value actually is. Because you can see how the analysis was performed and you can see the data that was used. That comes with the cost. And if it's a commercial building, it's even a greater cost, obviously. So just think about it, but that's one way we definitely offer opinion on value is through an appraisal process that will withstand scrutiny with respect to cross-examination and the like. And that's the other thing to think about, right? It's not just, do I have information that I can get into evidence? How will this stand up to the test of cross-examination and the like? And a good appraiser should, while we recognize there's going to be variations. I've had people call me, like divorce cases, a lot of times you would have an appraisal done if there were issues with respect to that. And sometimes the appraiser will say, what do you want? You want a high or a low? I say, no, I really want one that's what you think it's worth. I don't want high, I don't want low. We need to know what it will be. And only high or low, I'm just saying, is because, again, it's opinion. There's going to be variations. So they can go high, they can go low. I mean, and by high or low, I'm saying, a 10 or 20 grand variation, or maybe more these days with how inflated the houses are. And I think it's a little harder these days because you've got to really supercharged market. So, you know, houses now are selling well above asking price. So, I mean, it's almost a little difficult to predict what the market truly is. You're going to look at prior sales, hopefully recent prior sales.
So what would happen in a situation like we speak of Lawrence, where there was a catastrophic event? Now we're talking about market value, less depreciation. I would assume the whole area would depreciate. Now,
Well, but it should be before.
Okay.
It should be before this catastrophic event. Because you're absolutely right. It's a really good, it's an interesting question and a big problem because there were pockets
Right.
that were to a greater extent affected. But it should have been before this whole calamity than that what would exist, not what the problems are now. Because there are still houses, if both Lawrence and North Andover, I drive around here, there's still houses that are boarded up and not livable. And so that obviously is going to affect the surrounding values. I expect that they'll ultimately reach an appropriate number with the insurance carriers. But it was surprising to me because it's been a while now. I would have thought that a lot of those issues would have been resolved because, you know, people have to live somewhere. But there are still many pockets, not just, well, pockets. It really is pockets affected because all of a sudden, you're driving, you say, wow, you know, a couple right here and there's a couple there. So yeah, that's what you'd have to take into account. Unique personal property, hold on. Oh, so then we were on who can testify. So we had the plaintiff's proof, here in this case, of the market value less depreciation of the home and the personal property was sufficient to present a prima facie proof of the amount of damages. And so the court was wrong in directing the verdict against them. And the plaintiff's witness, Mr. Ryan, to testify as an expert. As long as you have that skill set that we talked about, or that combination of background, education, experience, and training, the fact is a lot of people can fit that mold. If we're doing it in the real world, I want someone qualified as an appraiser who has done this numerous times, who by both education and experience has learned to do this properly, and they're going to be able to withstand cross-examination with respect to their qualifications. This was a little sloppy here, but whether, as it says here, whether a witness is qualified to testify as an expert is a matter up to the trial court at the end of the day. You have to lay the foundation. Again, taking the idea from the abstract to the concrete, you're going to have to show what their background is, what their education is, what their experience is, what their training is. And then you're going to have to show what investigation they did, what analysis, what did it entail. You know, you want to lay the foundation so that we know that what they're going to tell us about the opinion as to value is reasonable, and it came from a good source and it's trustworthy as to how they got there. And if you do that by Q&A, then ultimately the likelihood is, as it says here, because it's within the court's discretion, that testimony will be allowed to stand as expert testimony on the value of what the losses were here. And that's, in fact, at the end of the day, they were lucky because I think they could have done a better job proving damages here. But it's still, the court felt that what they did offer was sufficient. Ryan had both a bachelor's and a master's degree in mechanical engineering. He had nearly completed the requirements for a second one in engineering. He's the owner of the testing lab. I mean, his expertise really sounds in a different area, but he was testifying with respect to the problems that were encountered here. Let's talk about Campins versus Capels, because this is a unique personal property case. And again, personal property has a lot of problems with it, actually, much more so than real estate, because real estate is much more of a public market generally, right? Deeds are filed at the registry of deeds showing what the sale price was. There's listing services that much of the information is online now. Much of the amenities of the home are able to be viewed online. It's much more public information readily available about real estate, houses for sale, as well as ultimate sales that have closed, that we can gain access to, that give us a lot more comfort in establishing market value as opposed to personal property. But that doesn't mean you don't do it. That means you just have a little bit of a harder time doing it. And as I explained to you, one of the most common ones is what's the value of the vehicle, right? That the vehicle has been now destroyed, and how do we put in value of the vehicle? Well, again, what would a seller sell the vehicle for and a ready buyer pay for it is the market value approach. But market value isn't necessarily in those little blue books that they used to have, and now it's online at kbb.com and the like. But it's an approach to help get us an idea as to what it is. If you think about it, if you're ever dealing with the insurance company, whatever book they're likely using is discounting because they find it beneficial to use that, right? They're not in the business of giving away the money either. So you have to figure out how to establish market value. One way is to go on Craigslist, go to the dealership, get some estimates to show what the value is. But a lot of that paperwork runs us into hearsay problems, right? So it comes back to, okay, I get the idea now. How do I put this into concrete terms as to what those values actually are? And that's easier said than done, frankly, for personal property, if you think about it. Because do I have to subpoena sellers in? Do I have to subpoena records from the car dealership to show what they're paying or what they're selling the vehicles that are similar to this vehicle for? Yeah, maybe if we can't get an agreement on it. A lot of times, again, as I said to you, some jurisdictions, Mass allows it, that a person can give their opinion on the value, what they believe the market value was of their automobile. So that's an area where that might offer some help. But again, the problem with that, at least in part, is that the plaintiff is obviously self-interested, has every reason in the world to inflate that figure as to value, and that's certainly going to be explored on cross-examination. So what we have to try and think about is, well, are there other sources we can get admissible evidence from to show what the value of that loss is? Well, let's look at Campins versus Campels, because it's kind of a unique case.
Can't you use like registration costs or like excise tax? Because if my understanding is not dictated based off the year of the car. So wouldn't that be a way to potentially?
It is, but again, that's one of those excise tax valuations. I think oftentimes come from the little NADA books and the books that the dealers have and the like. And oftentimes excise tax valuations are low. And again, like, your point is, well, if it's high or if I think it's fair, I can try and use it. Yes, but the problem is you still are going to be able to, you have to establish somehow that it is a reasonable and fair market value for that item. And that's not necessarily as easily said. It's much easier said than done. Personal property can be very difficult to value, but that's what we've got to do. Let's talk about Campins versus Campels, because here he's got pretty unique personal property to try and value. He had these rings, and he sued for the loss of these rings that were stolen from his home. the jewelry itself then was purchased by this Campins, who had some of these we buy gold type of things. And so Mrs. Capels talked to him, and he said, oh, the gold, I did take them rings, at least she says. He admitted to having bought the rings and melted it down, but he still had her sterling silver ring, which he returned to her. They sued for the destruction of the jewelry, and they wanted the value of their property back, and they were requesting treble damages because he destroyed their property knowing it was stolen, and took it from them and rendered it worthless to them. And there is a statute that allows in this jurisdiction for such a recovery under the circumstances for potential trebling of those damages. But what's unique about it is the property he's got himself, the property that's at loss here. They were 3 national racing championship rings awarded by the U.S. Auto Club and a wedding band with 12 diamonds. Now, again, we're going to move past the liability because Campins acknowledged that he had possession of these things, and I guess he said that he paid significantly less for them. Let's see, did we find Campins as much admitted having bought new out? Okay, we're going to get past liability because I don't really think it's an issue. They deal with it a little bit for a little time, but I think that's a given. Not that it's a given in this case because the real issue is on the damages, and that they clearly indicated that they belonged to him and Parnelli Jones, who was a famous driver. Now, let's see, where do we go with the numbers? 72, 77, and 78, he had won 5 of these rings in all. They were, as a result of a lot of effort, he was on the super team, and they had sentimental value to them as well, because as he saw them, they were enduring symbols of his accomplishment and the Auto Club's recognition thereof. And he was genuinely, at least the court felt, touched by the loss of these rings. Now, he admits, this is 716, that in 77 he purchased a duplicate of his 77 ring for a business associate for $349. And he said at the time of the actual theft, the price of gold was double, so that would get him to $700. He went on to testify that he personally wouldn't have sold these rings even for $1,500 or $2,000 a piece. He estimated their worth as between $700 and $1,000, finally settling on $750 when asked to be specific. So he personally, at the end of the day, values them at $750, even though they could be replaced for less than that. He had replaced one many years ago for only $350. And the wedding ring he wants the $700 for. So you see how they've calculated the damages here. 3 USA rings at $1,000 each gets you to $3,000. The wedding band is $700. $3,700 times 3 gets us to this $11,000 figure. Okay. So first of all, it is a judge trial, not a jury trial. So if you look at liability, Arabic 2, it is a judge's responsibility in a non-jury trial to make findings of fact and conclusions of law. We've talked about that before, right? Findings of fact are going to establish what both liability and the damages are here. The conclusions of law are the law the judge uses based on those facts to determine who wins and who loses. And in these damage cases, specifically, what the actual value of the damages are based on the evidence that was presented and received by the court. And the only way, as this says, that they can be reversed is if they're firmly convinced that the trial court committed error. And they're not going to be firmly convinced that the trial court committed error here. But the case does talk about, and it raises this important issue, first it gives us the law, right? When personal property is the subject of an award, damages are measured by its fair market value at the time of the loss. Fair market value being the price a willing seller will accept from a willing buyer. It's a pretty straightforward formula. And as it says here, there are some items that household goods especially become problematic because the secondhand market might be virtually non-existent and the value to the individuals who have them is actually quite high because they have them and they're fond of them and they use them regularly. So the value to me of my big chair at home is one thing, the value to anyone else is quite something different. Now, he wants $1,000 for these rings. The defendant in part is arguing, whoa, whoa, whoa. These are, you want value for your sentiment, for your feelings about those rings, not what the actual market value would be. We don't, they say, we don't award damages for mawkish sentimental value. What we're awarding damages for are the actual loss, what the market value of those rings were before or after, or what the replacement cost is. He argues, or the court argues at least on his behalf, they were coveted awards and symbols of certain achievements accomplished by very few. Such awards not having many willing sellers and therefore no real market. These rings should be valued differently than other property is what the language of the case says. Do you believe that there are property like this, like these rings, that need to be valued differently than just the value of the sum of their parts?
Yes.
Go ahead.
Well, it's like a Super Bowl ring. Super Bowl ring is timeless, unique, and those are made for those specific players who won that trophy. And this is the same kind of case. These rings are something that he won from a championship that's not to be duplicated again.
But that's for him, right? That doesn't create the market, does it? And even Super Bowl rings, we could go online. People have sold falling on hard times or decide they no longer want it. People have sold Super Bowl rings in the past, so there's a market for that. But do some items have greater value than the sum of their parts? Like a Super Bowl ring, especially to the individual who won it. That's a sense of pride and accomplishment. I don't know how many people have won the Super Bowl over the course of its existence, but there would seem to be a higher value than just what the cost to make that ring is. For Campins versus Capels, because what they say is the sentimental value is a problem, right? We do not mean mawkishly emotional or unreasonable attachments to personal property, but we do recognize that some items have a sentimental value that improves the value of that property, right? Something from your grandmother, perhaps, right? And others who had something from their grandmother could appreciate that little table or whatever it is worth more than just what some other 80-year-old table might be. While we are referring to basically those items generally capable of generating sentimental feelings, not just emotions peculiar to the owner. In other words, any owner of these USAC rings would have similar feelings. The most apt analogy to our situation is that of the trophies. In 2 cases, courts have awarded damages based on the consideration of the blood, sweat, and tears expended to win those objects. So we can put a greater value on them because there is that sentiment shared by others for similar property. Perhaps that's what the case seems to say, right? And if you look at the language here, they do reduce it a little bit, right? Actual estimates of their worth to him range from $700 to $1,000 each. However, he himself settled upon the $700 figure. Campins alternatively argues each ring was worth $67 at wholesale gold prices. $135 to $200 retail gold, at $349 replacement in '77. We believe the evidence justified an award of $750. They knock it down a little bit, but they give him still more than what he said they're worth at $7, but they're still giving him well more than what the sum of their parts is. And I think that's because of the blood, sweat, and tears taken to achieve them, and then the sentiment that others would potentially share with it as well. But again, not Marcus' sentiment, the general appreciation for having obtained that property. The court does, this court though, does reject the whole idea that you can get to 1,000. That's speculation. So they're going to knock it down, but they are going to give him some value beyond the value of the sum of their parts. So that's my question. I have this baseball here. How much is that baseball worth? Is that just whatever a Major League Baseball goes for? Because I actually have another baseball downstairs. I've got 2 baseballs, and I want you to think about. Yeah.
Depends on who signed it.
That is signed by Tony LaRusso, who now works for the... okay, I'll give you both stories, and you tell me, or you can think about them, and we can talk about... I'm going to give you 3 questions for next time to work with. Okay. So that's my boys when they were very little. Okay? And that's a baseball. That's Tony LaRusso. He's signing right there. Okay? That was one of the best days ever. And they were all competing with these 80-year-old people in Florida to try and get the baseball. They won the day, and he signed it. I don't know who that old lady is ruining my picture. But I have had this baseball since then, and I would not sell that baseball for $1,000. Now my guess is, well, first of all, so what is the baseball worth? I've got this one. I'm going to tell you the other story, and then you can start to think about it.
I think the intrinsic value you place on it also matters. Aside the market value also, there might not be even inflation.
Well, so what is the market value, though? Do we go on? Do we send one of you online to see what a Tony LaRusso signed baseball is? Or do I tell you what I say the market value is? Okay, I've got another baseball downstairs. My hands were full. How many of you have ever caught a ball at a baseball game? Oh, well, really? A Major League Baseball game?
No, I thought you meant playing baseball. No.
Oh! I was going to say, I was impressed. So how many of you caught a ball at a Major League Baseball game? Oh, still good. That's 3 out of 6. That's impressive. That's high. Okay. Did you catch it on your first attempt? Okay. So I didn't either.
I was in the area and I was a young kid, and somebody else actually technically caught it and just gave it to
Same.
me. You know?
Oh, wait a minute. No, give it in.
My hand was there.
No. You gotta catch it. Okay, so here's. Okay, after going to the ball game for probably, it has to be 35 plus years, I finally caught one. Okay? Not this one, another one. I wouldn't sell that I don't even remember who hit it, because that wasn't the important part. The important part was I caught it. I wouldn't sell that. Now, there's probably a number I would, but it's not small, because how many years did I go to the ball game before I caught the ball? So I've got that baseball. So I got this baseball, that baseball, and I've got one other item that I want you to value. We can talk about all three of these next time. I got a pair of rosary beads that supposedly are blessed, and they have healing powers. They're from Medjugorje. So, and they're just little wooden beads. But I wouldn't sell those. And I do believe, by the way, and not just believe, I've seen the power of the beads.
Did you go there?
I didn't go there. A friend
I
of.
have friends who went to.
Oh yeah.
Wow, I said it was crazy.
I've seen. Okay, so here's the point. If you believe, these beads have power, even if it's, well, what I do actually believe, so I'm not going to diminish that. At any rate, they're wooden beads. They probably don't cost a dime, 15 cents, or whatever over there to make. But I wouldn't sell them. I actually have some extras. I would give you ones if you were sick, but I wouldn't sell them. So what's the market value for those beads? Because if we could go online, I'm sure we could go online and find that you can buy them for $2 on the internet, and they'll be ship them on Prime right to your house, right? Free. So I've got 3 items of unique personal property, and the religious items I do want you to think hard about, because I think if this case says, and I think the baseballs too, but I think we tend to have a tendency in law school to sort of pull back on all the religious stuff at any rate, but this is my question. If there is a market there, the people would share the view. It's not just then Marcus sentiment. There are those that believe in those types of things that potentially enhance the value of those items. Because how many of us have a religious item in the house, right? So what's the value? How do you value things like that that the worth or the value is well beyond what you might be able to pay? Now, what did you find? Tony La Russa's signed baseball?
Yeah, $89.
That's it? $89? If there's someone came into my office and took this, all I get is $89. Look at look at what they're taking from me. Those are pictures of the kids. Honest. So that's it. So you've got a market value. It says Tony La Russa's autographed baseball is $89, and that's
With the glass display and everything.
oh, with my little glass case and everything, and not a penny more.
No.
Okay, what about?
$7.99 for shipping and handling.
Okay, wait. What about the baseball I caught? That's nothing, because that's not even autographed. That's whatever Major League Baseball goes for. Or don't. How come Campins versus Capel's got so much more than the value? And what about the religious items? They don't have a value beyond the sum of their parts. I thought that's what Campins versus Capel said, is some items can be valued beyond the sum of their parts.
Maybe because this was an award. This was a trophy. This was like a Super Bowl.
Well, this
ring.
was a trophy to these guys. I'm telling you.
Yeah, a personal trophy, but not an actual sporting trophy. You know what I mean?
But I don't know. I don't know what you mean. To Campins versus Capel, so that was a personal trophy to him.
But it was
Catching listen. You know how catching a baseball in a baseball game is a trophy, to the point where 2 of you lied about it, right? Someone handed it to you.
Well, it dropped all over the place and all day.
No, it's too late now, Jeeves. No, but I mean, isn't that a trophy?
Yeah.
And so your trophies are worth more, but some other items of sentimental attachment aren't. And what are you going to do about those religious goods? Because that's really particularly problematic, I would think, because there will be people who say, no, I'm not going to sell. That is not for sale. Even though you look at it, maybe it's just a candle, but it's important. We had, I shouldn't tell you. What I think people do, that we had rosary beads actually made from the flowers of my aunt's funerals, so that you have something more personal like that to remember them. Now, they gotta be worth more, because they never will get those flowers again. They gotta be worth more than, again, the sum of their parts. So if one of you came in and stole them from the house, I'm limited to what, 50 or 75 bucks, whatever the cost is, even though you've stolen that. Go ahead, let me get,
I think for that baseball, it could be the market value times the amount of years that you've had.
Exactly. I also would think so.
times I had it or times that I went to the park trying to catch it?
I would say,
Both.
I would say both. What about the longevity of the item itself? Maybe this could live for additional 120 years or even 500 years to the 10th generation. What if we compute that to it?
But how does that, your value though, approach the value of this? Because if it's, how many years I've had it, well, I had all that, I got the value of that to appreciate for those years. I'm not gonna get it for the next 20. So is that the period? So 20 times the $15? Still doesn't come close to what I would sell either of these baseballs. I would not sell that baseball. And that sounds really stupid, because that baseball isn't worth, I mean, you can hardly even see, and again, it doesn't make a real difference that Tony La Russa autographed it. You can hardly see his name anymore. I don't really care. It's not about him. It's about the boys. You think about it for next time. We'll talk about valuing these unique items of personal property that have value, but it's the value comes from what we think and what we believe, and to us. And are we just saying, well, the court's never going to give you that? Because that's what I want you to think about. We'll talk about that next time.